Employment Law This Week. I'm George Whipple. Our top story, the trend towards equal pay regulation continues, with new legislation in New York and New Jersey. The New York City Council has voted again to broaden New York City human rights law, amending it to state that any exception should be construed narrowly. Among other protections, the law prohibits paying an employee less money based on gender. And following similar laws in California and New York, the New Jersey Senate recently passed legislation that would make it illegal for an employer to pay men and women different salaries for substantially similar work. Carleton Schaefer has more on the trend.
What we've been seeing over the last couple months in states like New York, New Jersey, California, Massachusetts, are states trying to pick up where the federal government has left off with the EPA, close some of the loopholes, strengthen the laws, and really try to more aggressively close the earnings gap between men and women, if not eliminate it. We're seeing a new era of transparency being ushered in by way of compensation data and the ability of employees to speak directly to one another and to share compensation data and terms and conditions of employment openly without fear of retaliation, without fear of retribution. In an era of increased transparency comes an era of increased accountability. I think it's very likely that you're going to see an uptick in litigation. I think it's very likely you're going to see an uptick in enforcement actions. I think it's very likely you're going to see increased penalties and increased headlines about employers who fail to comply.
Justice Scalia's death delays resolution of the mandatory union fees issue. Last Tuesday, the landmark California public sector fees case ended in a 4-4 split. Before Justice Scalia's death, many expected the High Court to overturn the Ninth Circuit's decision, ruling in favor of the teachers who claimed their mandatory union fees violated their First Amendment rights. The 4-4 split leaves the appeals court decision in place, allowing public employers to continue requiring union fees from both union and non-union workers. Workers' negative publicity about their company's products is protected, the Eighth Circuit says. The court upheld an NLRB ruling that a Jimmy John's franchisee should not have fired employees for suggesting that the public risked illness if they ate the restaurant's sandwiches. The workers were protesting that they didn't receive paid sick days and had to find their own replacements when they were ill. But the employer argued that the workers' actions were not protected by the NLRA because they disparaged the company's products. The Eighth Circuit affirmed the NLRB's 2014 finding that the employee's conduct was protected and that it arose out of a labor dispute between the employees and their employer. A Texas federal court defines commission under the Fair Labor Standards Act. A Gold's Gym in Texas classified its trainers as exempt from overtime because they worked primarily on commission. The trainers were paid a percentage of client fees for 1-hour personal training sessions. A U.S. District Court found that those payments were not bona fide commissions because they were tied to the hourly sessions and not decoupled from time. The judge ruled that the compensation system should be classified as an hourly wage and that the employees should be entitled to overtime. The Department of Homeland Security expands its F1 STEM OPT program. The DHS recently released its highly anticipated final rule expanding and modifying the F1 STEM optional practical training program. A 2015 district court case found procedural errors in the DHS's program, putting the current employment and OPT extension of thousands of foreign nationals in jeopardy. This new final rule is DHS's response to the court's decision. Among other changes, the 2016 rule extends the potential work period to 24 months and puts into place new, tougher requirements for employers to satisfy. And that brings us to our tip of the week. Eric Topel, Associate General Counsel for Danone Foods, Inc., has some advice on best practices when hiring from a competitor.
As part of the initial screening process, your recruiters or talent acquisition should inquire of prospective candidates as to whether or not they're bound by any restrictive covenants, such as a non-competition provision, a duty of non-solicitation, anything that could in any way impede their ability to work for your company. To the extent that they are going to join your company, include in the offer letter certain protections. So first is to make clear that In the event that the former employer or another party were to pursue your company for violating some sort of restrictive covenant or other agreement, that you have the right to terminate them immediately, whether they're at will or privy to an employment agreement. And secondly, we encourage you to include language that in the event that your company is sued by another party, that this employee will indemnify you.
Thanks, Eric. That's it for Employment Law This Week. Thank you very much for watching, and we'll see you next time.